This conference will now be recorded.
Hello, and thank you all for coming to the second webinar in the Mid-Hudson Library System's HR Legal Issues series. My name is Casey Conlon. I'm the Library Sustainability Coordinator here at Mid-Hudson, and also with us today is Kirsten Kruger, Library Sustainability Associate and Communications Specialist. Kirsten will be serving as our technical support today, so if you have any issues with the webinar, please don't hesitate to reach out to her. Sherry Fallon, who works as a compensation consultant at Cornell University, will be joining us again today, and this time she'll be discussing New York State's new Sexual Harassment Prevention Law and the Family Paid Leave Act. You should have all gotten a copy of today's slides, and there will be a recording of today's presentation available at midhudson.org. We'll send out an email later with a link to that recording so you can share it with any relevant library staff and stakeholders. You have all been muted to limit some of the technical issues that can go along with webinars, but you're very welcome to ask any questions you might have about these laws and how they apply to you and your library. If you have a question during the presentation, please put it in the chat box. I'll be watching for questions and we'll ask Sherry about them after her presentation. As a reminder, Sherry will be presenting the final webinar in our HR Legal Issues series, which will cover key employment legislation and compensation issues, and that will be on Tuesday, March 26th at 2 p.m. During that webinar, we'll go over the top 10 legal mistakes by supervisors, the Wage Theft Prevention Act, equal employment, the Americans with Disabilities Act, and the Federal Family Medical Leave Act, among others. And you can register for that using our calendar at midhudson.org. So Sherry, thank you for joining us today, and we're looking forward to your presentation and your guidance on the New York State Sexual Harassment Prevention Law and the New York State Paid Family Leave Act.
Thank you, Casey. We're first going to start, and we're going to cover the New York State Paid Family Leave Act that went into effect in January of 2018. When I'm finished with that section, we'll pause for questions so that we can sort of keep it all together and we don't forget as we're moving forward. And then we'll move on to the New York State Sexual Harassment Law, which went into effect in October, and we'll cover the new law around policy and training. So we'll start with the New York State Family Leave Act. It became effective January 1st of 2018. It covers all private employers in New York State. Employers are required to inform their employees about their rights, either in an employee handbook or other written materials. The law also covers the amount of time an employee has to work. It's 26 consecutive weeks as a full-time employee or 175 days as a part-time employee. And the law covers new parents, family caregivers, and military families with active duty employment. Under this law, employees can only waive coverage if they regularly work fewer than 20 hours per week and won't work the 175 days in a year, or they regularly work 20 or more hours per week, but will not be in employment for 26 consecutive weeks. If an employee meets any of this criteria, they are eligible to waive the coverage. Now, there is a waiver form that New York State has released, and that must be filled out. And if they choose to waive coverage, they will not make the contributions, but they also will not be eligible for the paid family leave benefits. So that's really important to know. So it's really important for an employee who wants to waive coverage to know basically it would end up being a temporary employee working 20 or fewer hours and without working 26 consecutive weeks. If an employee's schedule changes during this time, any part of the year, such that they no longer qualify for the waiver, their waiver is automatically revoked. So if they go full-time and they're going to work the 26 consecutive weeks, their waiver will be revoked within 8 weeks of the schedule change. And an employee can also voluntarily revoke a waiver at any time. So if someone is going to work 15 hours a week for 175 days and they choose to opt in, they are allowed to do that. People cannot choose to waive out of the coverage just because. So there's very very specific criteria about when you can waive the coverage for the New York State Family Leave Act. This is who the Paid Family Leave Act does not cover. It does not cover public institutions, state or federal government, political subdivision of the state, or other public authorities. So in your library association, under the Mid-Hudson Library Systems, the association libraries, they are considered private and they are covered, okay? The public ones, the municipal public libraries, school district or special district public libraries are not covered. However, I do recommend before you decide not to be covered that you just check with legal counsel. But the law does say these public municipalities, school districts, and special district libraries do not have to offer coverage to their employees. However, you can opt in if you would like. So any public institution, the state or federal government, if they would like to offer this coverage to their employees, you absolutely can. If you have a collective bargaining unit, this has to be put into the contract, okay? You would have to open negotiations and go that route with it, but it can be offered in a public institution. Under this new law, an employee can get paid time off for the following reasons only. It's to bond with a newly born, adopted, or foster child, to care for a close relative with a serious health condition, or to assist when a family member is deployed abroad on active military service. And those are the only three conditions in which you can apply for the New York State Paid Family Leave. During the time that you are approved for this time, and it will go through your insurance carrier, whether you're self-insured or you have a private insurance carrier, during the time that you've been approved to be on the paid family leave, you will have full job protection. This means you do not have to worry about keeping your job when you need to take the time off, because you are entitled to your job or a comparable job upon your return, okay? But you are protected under this act. Health insurance coverage will continue while you're on the paid leave, but you will be responsible for any premium payments that you regularly make, whether that comes out of your paycheck automatically or if you take all substantial time off and the employer can bill you, but your health insurance will remain. Your employer is prohibited from discriminating or retaliating against you for requesting or taking the paid family leave. And that's really important to know, because unfortunately, this does happen. So once you've been approved for the paid family leave, your employer cannot discriminate or retaliate against you. Also, you do not have to take all of your sick or vacation time before using paid family leave. I will show you in a couple slides how this works, but what you can do is supplement the time that the New York State does not give you. Okay, so this is a little bit different from the Family Medical Leave Act. You are not required to take your own PTO time, whether you have a separate bank for personal, sick, and vacation, or if it's all wrapped up into PTO. So in 2018, the government put this into effect, but they gave employers the ability to do this in incremental steps. Some companies decided that doing this, trying to do the incremental steps year after year and trying to implement this via payroll, or even, through all the paperwork that needs to be done and incrementing the time off, incremental times off, employers decided some went right up to the 12 weeks and 67% of your weekly wage. Okay, you do not have to do that, but by January 1st, 2018, you as the employer had to allow up to 8 weeks of time off, whether it's all at once or they could take it like a day at a time. So what would happen is in 2018, they received 50% of their weekly wage. So if they had to take 8 hours off one day, they were only responsible for supplementing 4 hours, and the employer paid for the other 4. In 2019, this just past January, that increased to 10 weeks full time, and it's for one event. So you have to file for every event. So if you have a child, you would file for that event. If you have a serious illness, you'd have to file for the second event. And each event, you are allowed to take up to, right now we're 10 weeks and 55% of your average weekly wage. So with that, payroll would figure that out, and you can do it with or without supplement. That is on the employee's choice. Next year on January 1st, it stays at 10 weeks, but the employee will receive 60% of their average weekly wage. And then in 2021, the full 12 weeks will be available, and it's 60% of your average weekly wage. So 2/3 of your day would be paid through this program, and 1/3 the employee can supplement out of their own time or just not take the pay for that 1/3 of that time. Every year, an employee, if it's an ongoing serious condition or illness, the employee will have to refile every year for that event. Okay, so this goes year to year, and it's a rolling calendar year, not, January 1st to December 31st. So it's when the event starts and approved, when your doctor or the doctor says this is when the event occurred and started, say that's February 1st, you would get to January 31st of the following year, and then you'd have to refile for February 1st to January 31st again. So it's an ongoing filing every year. And again, employers, I'm not sure what the Mid-Hudson Library System did, but you could opt to offer the maximum coverage immediately, or you could take it step by step up until 2021, where the maximum will be 12 weeks and 67% of pay. So employees do pay for these benefits. It's a small weekly payroll deduction, and it's a percentage of their weekly wages, but it's capped at $107.97. Okay, and the 2019 payroll contribution that just started is 0.153% of the employee's weekly wage. Okay, and employees earning less than that average weekly wage, which is $1,357 per week, will have the contribution amount less than that cap of about $108. It'll be that 1.53%, and it's consistent with their actual weekly wages. So no one will pay more into it than the $108, and then you're fully covered up to that 12 weeks. And we're at 8 weeks, I think, or 10 weeks right now. My employer chose to go right for the maximum, so that's why I was a little confused by that. But no, right now we are at 10 weeks and 55% of wages. So employees, a lot of the responsibility is on the employees under this act. So employees are responsible for submitting the paid family leave request to your insurance carrier. If you're self-insured, typically that's probably your benefits office or your workers' compensation office. It is not the employer's responsibility, okay? This is completely up to the employee. The employer's role is simple. The employees notify you, and they say at least 30 days before the start of the leave. However, exceptions are made for, emergencies and last things that just come up. The employers must provide the request forms. You can put them on a website, in a handbook, in your HR office, but they must be available for people upon request when they come in and ask for them. And you must complete the employer's portion of the request forms. So when the employee gives you the form, you have 3 business days to turn it around and return it to them. So if there's a delay for some reason, employees do not have to wait to proceed. They can send, it's called the form PFL-1, that it's the employees responsible for filling out, along with the rest of their request package, directly to the insurance carrier, and then the insurance carrier will continue to remind the employee to get the rest of the information. It cannot be considered incomplete solely because the employer did not fill out their part within the 3 business days, okay? Employees must submit their completed request package within 30 days after the start of their leave to avoid losing the benefits. So once you know an employee has to go on the leave, the employee has 30 days before the start of their leave, or within, if it's an emergency and it started immediately, within that time frame to get all of their information in. So in most cases, the insurance carrier must pay or deny the benefits within 18 days of receiving a completed request or the employee's first day of leave, whichever is later. So if you have an insurance company, they will be responsible for paying that 55% right now. If you're self-insured, that would just go through your payroll. So it depends how that's handled through your HR office. Here's the employer's checklist that's really important that you follow. You must ensure that you have paid family leave insurance. New York State designed the paid family leave to be easy for employers to implement. If you're required to carry disability benefits insurance, you're also required to carry the paid family leave. So when this was going into effect, if you do have a separate insurance carrier and you're not self-insured, your insurance carrier automatically said, this is now covered. Premiums may have gone up for the business, but it was automatically in there as long as you carry the disability benefits insurance. You must inform your employees about the paid family leave, okay? It can be in an employee handbook, other written guidance to inform them on this and give them information. It can be on a website. It can be done electronically through email, but it just has to be out there for the employees. There is model language for the materials that are available on the website. It's called the paidfamilyleave.newyork.gov. You can customize it if you want, or you can just fill in the blanks that they give you and then print it as is. Sometimes it's a little easier and safer to just fill in the blanks and put it out there for your employees so that you cover everything New York State has asked you to do. There's a statement of rights available for the employees, and that must also be available to the employees somewhere written on a website in a handbook. You collect the employee payroll contributions to pay for the insurance via payroll. Okay, so if you have an outside payroll service, they know this. It's been put into the system for those, who are covered. So this is done through your payroll system, so you don't have to worry about collecting it in-house. You may withhold employee contributions at the rate set by the DFS each year to pay for the cost of the insurance until they reach their annual max, which is about $108. And again, there is a deduction rate and annual max contribution calculator available at the same website. And it's a good website to go through and look at. I did send out additional fact sheets to you about what employers have to do and what employees are responsible for. And those are probably great fact sheets to have out there for both employees and employers. You can hang them in a common area or something like that, and that way employees have been notified. But the paidfamilyleave.newyork.gov is a really nice website, and it's got the calculator out there, the deduction calculator. It's also recommended that you notify the employees before you start deducting it. So back in 2018, prior to just taking something out of their paycheck, some type of notice should have gone out saying this law is out there and this is what will be taken from your paycheck. An employer is also required to offer waivers to those who qualify. Again, those who may not qualify and can sign the waiver may opt in, and that will be their choice. So you offer them the waiver form, and then make sure you keep that with their employee file so no one can come back and say, why wasn't I covered? If they've signed the waiver form, make sure that's in their file and easily accessible to you when you need to. You must post an employee notice. Like I said, I sent some fact sheets out that would be good to post in a common area if you have a kitchen or an employee break room or anything like that, just so that it's out there. It may be updated every year with the new coverage unless they've outlined how up until 2021 it will be, the leaks and coverage will be upped. So it must be in plain view. and it's sort of how you would hang your workers' compensation or disability benefits insurance. So, and again, putting it on a website and notifying employees that it's out there is fine as well. And you must handle the requests. So if someone comes to you with a paid family leave request, you can't just brush it aside and say you'll get to it. They must be handled pretty expeditiously. When they apply for the leave, they will be given the request for paid family leave form, the PFL-1, and you need to complete Part B, and then make sure that they get that back within 3 business days, because it does not stop their, they can still move forward with their request, and then employers can be in trouble if they don't get it in on time. So I know there's a lot of confusion around the Family Medical Leave Act versus the New York State Paid Leave Act. Remember that the FMLA, and we'll discuss that in the next webinar, is a federal law, okay? The New York State Paid Leave Act is New York State specific, so this isn't something that came down from the federal government. And some of the differences are FMLA provides up to 12 weeks of unpaid leave. So anything you take under the FMLA must come out of your banked time, whether it's sick, vacation, personal, PTO, however you have that set up. PFL, the paid family leave, they provide up to 12 weeks of partial paid time off. Again, right now we're at 55%, and that will go all the way up to 67% eventually. Under the FMLA, you take your total leave time in 15-minute increments. So this could be you went to a doctor's appointment for an hour and 15 minutes, and they will deduct the hour and 15 minutes. For PFL, it's in 1 full day increments. So if you go to you have to take all day, 8 hours, and it's 4 hours right now with time, you won't be deducted out of your time until it becomes a full day increment. So you would have to take another day at halftime, and then they would take those 2 days, and it would be 1 full day. Under FMLA, you need a minimum of 50 employees to comply. For PFL, it's 1. It could be just yourself. You're self-employed. It's 1 employee. That's all you need that's required to comply. Under FMLA, employees must work for their current employer for 12 consecutive months, working at least 1,250 hours. Under PFL, they must work for their current employer for 12 consecutive months, working only 20-plus hours per week. So it's about the hours you work per week, not a maximum or a minimum set of hours throughout the whole year. FMLA was put into place to care for your own personal illness. So it was not meant to be used for family members or active military deployment. But under PFL, that is meant for another family member. And we will get to that definition, okay? Under PFL, you cannot take that time for yourself. So if you're the one with the serious illness, or you're the spouse of someone who's just had a child or foster child, you cannot be covered under PFL, but you would be covered under the FMLA. So the employer under the FMLA has the option to require employees to use existing sick or vacation time. So if you go out on FMLA, say for 3 weeks, as your spouse or partner just had a child, they can require you to use your sick and vacation to supplement your pay. Under PFL, you cannot. Okay, an employer cannot require the employee to use existing sick or vacation. And under FMLA, if I went out and had a child, they can require me to use my existing sick or vacation time, as where your spouse or partner would not have to under PFL. These are some of the major differences between the FMLA and New York State. And the first one is, PFL, the paid family leave, is for someone else. FMLA is for yourself. So, and there's, 12 weeks of unpaid leave for yourself under FMLA, and under paid family leave, it's partial paid time off to care for someone else. So who qualifies as a family member? So under the FMLA, a spouse, a child, or a parent qualifies as a family member. Under the paid family leave, it's all of the above: a spouse, a domestic partner, a child, a parent, even grandparents or a grandchild. Okay, whoever the caregiver is, they're all covered under the PFL. For military caregiving, it's the spouse, child, parent, or next of kin under the FMLA. The only one not covered under the PFL would be next of kin for the military caregiving. Everyone else is covered: spouse, domestic partner, child, parent, grandparent, and grandchild. So PFL offers a broad range of coverage in who qualifies as a family member or a caregiver under the military scenario. So who's considered a parent or child? Under the FMLA, 18 years or older, but incapable of self-care. Okay? Both accept biological, adoptive, step foster, or in-law parental relationships. The noteworthy differences is just that. The FMLA only covers 18 or older. Under the PFL, in-laws, domestic partner's child will be covered, but not the 18 or older. So here's some of the differences on who covers what. Again, PFL offers a little bit broader range of coverage. Are there any questions about the New York State Paid Family Leave Act? I know it's a lot to cover.
Hi, Sherry. Thank you. So we did have a couple questions, and if anybody else has any other questions about this, please go ahead and start typing in the chat box, and we'll get to them. So our first question, is the PFL request form something that the library would make up, or is that something that we get from our insurance carrier?
Actually, the forms are very easy. They're right on that Paid Family Leave Act NewYork.gov. They've already made up the forms for you. There are some that you could make up on your own if you wanted, but the ones New York State gives you are obviously from them and sufficient enough and good enough. So I would go right on there. I would print them off. It is up to the responsibility of the Mid-Hudson libraries to have them available. So you can either put them on a website for people just to click links and download themselves. One of them, it's called the PFL 3. It says do not scan. So you'd put the actual document up, and that's not something you could scan back to your office. It's something that would go to the provider's office and given back to you, and you'd have to mail in or hand deliver. So you can get them right off the website, and I highly recommend using the New York State ones. If you want to create an employee version, like with your stationery with all of your headings and stuff on it, just copy it right off the state and like cut and paste it into the document and just leave the New York State wording. It's the safest way to make sure you've covered everything that they're asking you to cover. So they are right on the New York State. Let me get that website. I believe it's paidfamilyleave.newyork.gov, and all the forms will be right out there for you. They're called a PFL 1 and a PFL 3. And there's also the Statement of Rights out there on PFL 27IS. So, yep, paidfamilyleave.newyork.gov, and all the forms are available in the employer section. So, but again, Mid-Hudson, make sure that in your HR office or on a website somewhere that's been announced to the employees, here's where you have access to the forms, and they're readily accessible to them.
Okay, thank you. We had another question. Can you qualify for both FMLA and PFL?
So you can, but it wouldn't be for the same event, okay? Because FML is if you personally have the serious illness or you personally had the child. So that FML is only used for yourself. PFL is in use if a family member has the child, or or has the serious illness, and again, or the active military deployment, right? That's used if you're the caregiver for someone else. Does that make sense? So it's easy to think about it as long as it's all about you and it's your illness, or you've had the child, or you go on active military deployment, you can use FML that's unpaid. If it's a spouse, a child, a domestic partner that went on the active military deployment, or has the serious illness, or had the child, again, foster, biological, adoption. If someone else in your family did that, then you use PFL. Does that make sense?
I guess so, but PFL, you get paid when you go out on PFL.
Yes, you do.
But FMLA, you don't get paid, right?
Nope. Exactly. So if it's you who has, let's say, serious illness, if I have a serious illness, I would file for myself to be out under the Family Medical Leave Act, which would give me up to 12 weeks, but it's unpaid unless I choose to supplement my time with my own existing sick or vacation time, or PTO time, however you guys set that up. If my child has the serious illness, chronic illness, I can file for PFL. I will get partially paid, and again, depending how you implement the program. Right now it's 55% average weekly wage. I would get that 55% from my employer or their insurance carrier, and I can either supplement the other 45% with my existing vacation or sick time, or I can choose not to. So, and the employer cannot require me to supplement. As we're under the FMLA, they can. So that's really the big difference. PFL really, it covered the employee for someone else, for another family member, as where the FMLA only covers you personally. Is it a little more clear?
I think so. We had another question. Are employees required to enroll in PFL?
Yes. If you're a private employer, again, we'll go back right there. So the association library employees, as long as you meet that minimum of 20 hours per week and 175 days a year, you cannot opt out of this. You are required to be in this program, and you would receive these benefits. And again, they would deduct from your paycheck. It's a maximum of $108 a year. For public employers, like the municipal public library or the school district library, they do not have to offer this. However, they can opt in, but once your employer opts in, so do you. So does the employee. Okay? The only time you can waive coverage once everyone has opted in is under the criteria that you work less than 20 hours a week, and you won't work the 175 days or the full year.
Okay, thank you.
Yep.
And I had another question too. If you had questions about this, like if an employee came and they wanted to fill something like this out, who would you recommend we reach out to? Would you go to the website and see if there was somebody at the state that could help you, or would you reach out to your insurance carrier?
I would go right to your insurance carrier, because they should know this law front and backwards now, how to apply it, what the coverage would be, and even they also should have the appropriate forms. Although, again, as an employer, you must have them somewhere for employees. I would start with your insurance carrier, or, if you have a benefits office or even an HR person. So as an employee, you'd start with your HR if you have HR. And if not, you can contact your insurance carrier. But even that website, the paidfamilyleave.newyork.gov, is very thorough, and it really gives you a step-by-step process of how to do things. So the fact sheets that I sent along with the PowerPoint, if they haven't been distributed, they are really helpful for employees and for employers, the requirements for both. So, but start with your local HR if you have local HR. If you don't, I would go right to your insurance company and also reference that website and the fact sheets.
Okay, great, thank you. Again, if anybody has any questions about the Paid Family Leave Act portion of this presentation, you can type them into the chat box. We have another question. If an employee has 3 weeks of PTO, can they take that in addition to the 10 weeks of PFL for 2019, or does it have to be used concurrent with the 10 weeks to earn more income?
So what would happen is, for the PFL, say you're approved right now. Oops, let me get where I'm going here. So right now, if you're approved for the 10 weeks at 55% of your average weekly wage, you are, as the employee, you can take the 10 weeks and only receive 55% of your pay. You do not have to supplement with your 3 weeks of PTO. However, if you take the 10 weeks at only 55% and then you go out for 3 weeks on your PTO, you are no longer covered under PFL. Okay, so you would lose that. You would lose the coverage because it's only up to 10 weeks, and if you took your full 10 weeks at the 55% without supplementing pay and you had your 3 weeks left, those 3 weeks that you would go out in addition is not covered under the PFL. So again, I don't recommend employers ever retaliating or discriminating against anyone who has to be out for any of these reasons, because it's a whole different legal side to it. But you would not have the protection of the PFL on those 3 weeks of PTO. So once you've exhausted your 10 weeks, then it's exhausted and the coverage is over until the following year if you have to file again. Does that make sense? So if you've exhausted your 10 weeks and you decide to take 3 additional with your PTO time, those 3 weeks of PTO time you are not covered under the Paid Family Leave Act, and you would lose some of the benefits of that, like job protection. And again, you're always covered for discrimination. I'm trying to find the slide really. And you would be responsible, again, for your health insurance coverage, whether they take it out of your paycheck or you pay the premium. So that would be the only thing about that. If you exhausted your 10 weeks and then took an additional 3, you would lose this coverage right here, the full job protection, health insurance coverage, if it was not taken out of your paycheck and things like that. Does that make sense?
Yep, you got it. Thank you.
Yeah, the 3 weeks of PTO would have to have approval from however your policy is written, and most of the time it's approval from your supervisor to be able to be out that long, to meet business needs and all that. So if they can't approve you for the additional 3 weeks, then you wouldn't be able to take it because you're not covered under this. You'd have to wait for your next rolling calendar year to reapply. Does that make sense?
Yep, I think you got it.
Okay.
All right, maybe, does anybody else have any other questions about the Paid Family Leave Act before we move on to the sexual harassment prevention laws? Maybe we'll give it another minute.
Okay. I'll go back to, this is a good slide to hang up somewhere. It will tell you the difference between someone taking Family Medical Leave Act versus Paid Family Leave Act. And then these next slides right here, you know, who's covered under what, like FMLA versus PFL. And again, FMLA is a federal law, and the PFL is a New York State law.
All right, so I'm not seeing any questions about the Paid Family Leave Act, so maybe we'll move on to sexual harassment prevention. And we can always come back to this and ask more questions later, of course,
Yeah.
right?
Yeah.
Okay.
Oh, yeah. At the end, you know, we'll cover the New York State sexual harassment law, and if you remember a question as we go through, just type it in, and we'll make sure we cover all the questions at the end. Even if there's an FLSA question, which we covered in last seminar, I'll take that also.
Go all the way back. All right.
All the way back.
We're going to move on. Questions in the chat box if you got them, okay? Thank you.
Okay. So now we're going to cover the New York State Sexual Harassment Law. And again, this is a state law, not federal. This began on October 9th of 2018. And this law says all employers, public and private, must provide a sexual harassment prevention policy to all of its employees and must be given to the employees on an annual basis. So it started on October 9th of 2018. So on October 9th of 2019, you would have to redistribute the policy. And again, it can be electronic, it can be an email directing people back to the website. However, you communicate policies. This has to be done on an annual basis. Okay. Also, as of October 9th, 2018, all employers must provide sexual harassment prevention training on an annual basis to all of its employees in compliance with a sexual harassment prevention training program that was developed by the New York State Department of Labor and the New York State Division of Human Rights. This law expands protection of the employee against sexual harassment by non-employees. And this is really important to expand the protection to non-employees, gives the employers a lot of liability here. Non-employees can be a contractor, a subcontractor, a vendor, consultant, anyone providing services in the workplace. So, you know, independent contractors, temporary workers, equipment repair workers, cleaning services. So it's really important that this policy is out there and you monitor who comes in and out and who has contact with who. It prohibits the inclusion of non-disclosure provisions in any employment or settlement agreements that relate in any way to claims of sexual harassment. It used to be that if you could reach an agreement with someone who filed a sexual harassment complaint, they could sign a non-disclosure and not be able to talk about it. That is now illegal. No more non-disclosure agreements provisions can be written into a settlement agreement. And it also prohibits the use of mandatory arbitration. People would put in, you know, a policy that if you filed a sexual harassment complaint, it automatically went to arbitration if you couldn't reach a settlement. That has been removed, and it's no longer viable. Let's see. So when you're writing or revising your sexual harassment policy, you now must include the following. The statement must prohibit sexual harassment consistent with the guidance issued by the Department of Labor in consultation with the Division of Human Rights. They have put out there some guidance on what could be sexual harassment. You must include examples of prohibited conduct that would constitute unlawful sexual harassment. And that's a tough thing to do, other than the obvious ones, as sexual harassment means something different to everyone, but you must include examples. You must include information concerning federal and state statutory provisions concerning sexual harassment, the remedies available to victims, and a statement that there may be applicable local laws. So although this is New York State, if your local municipality has additional sexual harassment laws that go above and beyond, those also must be in your policy. must include a complaint form and a policy on how an employee can submit a complaint. And it must outline the procedure for timely and confidential investigation of the complaints that ensures due process for all parties, not only for those who file a complaint against someone for the sexual harassment, but it also must ensure due process for the defendant of that complaint. And all these must be in written form in a policy. Again, they can be on a website. They can be in a printed employee handbook, but it must be accessible to everyone. New York State has prepared a model policy. It is out on their website, and I can send you that website. It's actually in the PowerPoint in the notes section if you guys have this, and it's a really good idea to go out and look at it and really try and model your policy after New York State, because it really will protect you. And there's also a model complaint form that you can take down and put under your stationery and put out there for your employees. The policy must also include statements informing employees of their rights of redress and all available forums for adjudicating sexual harassment complaints. It must clearly state that sexual harassment is considered a form of employee misconduct and that sanctions will be enforced against individuals engaging in sexual harassment. And it must clearly state that retaliation against individuals who complain of sexual harassment or who testify or assist in any investigation or proceeding is unlawful. So all these things must be spelled out step by step. And I'll tell you, during an investigation or when a complaint is filed, or if somebody files a counter complaint, consistency is the key. Treating every complaint in the same manner, step by step through your policy, is very, very important. Because you don't want to treat one complaint one way, another complaint a different way, and then the employee comes back and says, well, why was I treated differently? And then they file a complaint for discrimination. So consistency with this policy is very, very important as you're moving through your procedures that you have outlined. So on the training piece of this, each employee must receive training on an annual basis starting October 9th, 2018. New employees must be trained within 90 days of their hire, and then on an annual basis after that. All employees, that statement includes not employees, managers, supervisors, and board of directors or board of trustees. Any board you have overseeing your library systems must be included in your annual training on sexual harassment. Employers should provide employees with training in the language that is spoken by their employees, and the training should include as many of the following elements. If not, we recommend all of the elements be web-based with questions asked of employees as part of the program. It must be interactive. That is the key to this actual the New York State Sexual Harassment Prevention Training Policy, or the law, is it must be interactive. It must be able to accommodate questions when asked by the employees, include a live trainer made available during the session to answer those questions, and requires feedback from employees about the training and the materials presented. I've been to a webinar. It was given by attorneys at law, Bond, Shenick, and King, and he said highly recommends the training program should have a sign-in sheet, training materials printed if you can, video of the training, so as everyone's sitting in a training room. They actually say to take out a video camera or your phone and scan the room so you have proof of who is in the room. So if someone comes back and says, I didn't take the training, you pull out the video, you watch it, scan the room, and say, nope, that person was right there. It is very, very important that everyone goes, and make sure that the sign-out sheet, not only should they sign in, they should sign out at the given time, and hand out training certificates, and if you want to be safe, put a copy in their employee file. So the big deal on this one is that there's always proof that every year that the employees and new employees within 90 days have had this sexual harassment training, including your board of directors. So again, the training program must be interactive, and it requires some level of participation by those in the room being trained, whether, if it's web-based and it's a webinar like this, you have Casey monitoring a question box where he can, at the end, ask questions to the trainer. It must include an explanation of sexual harassment consistent with the guidance issued by the DOL. The training must include examples of conduct that would constitute unlawful sexual harassment. And I know from the presentations and trainings I've sat in, that can be uncomfortable. So you can give examples, but I would just caution on how explicit they become, but there must be examples. Include information concerning the federal and state statutory provisions and the remedies available to the victims. And it must include information concerning employees' rights of redress in all available forums. And that includes information addressing conduct by supervisors and any additional responsibilities for the supervisors. So this training must be very intricate. It has to include a lot of information, and most of all, it must be interactive so that employees can ask questions. Again, New York State has prepared a model of the sexual harassment training, and it can be utilized by the employers. However, it will give you the training, but what it doesn't give you is the interactive piece of that, and it's very, very important that you can use their training, but then you must add your own interactive piece to it as well. Okay. So what is sexual harassment? And again, this means something different to everybody, but it's unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature. And that constitutes sexual harassment when the submission to or rejection of this conduct explicitly or implicitly affects an individual's employment, unreasonably interferes with an individual's work performance, or creates an intimidating, hostile, or offensive work environment. So, and it can be either or. It doesn't have to cover all this, but anything that could come across as unwelcome, it's explicit or implicit and makes for a hostile or offensive work environment. The conduct of the offender must be offensive and unwelcomed by the victim. Okay, so it's not what the office might think was unwelcome, it's what that individual person feels is unwelcome or offensive. The harassment may still occur when there's no economic injury or discharge of the victim. The harasser can be a victim's supervisor, an agent of the employer, a supervisor in another area, a coworker, or a non-employee. And that is the most important part of this new law that they added in there, was the non-employee piece. And the victim and harasser may be a woman or a man, and the victim does not have to be of the opposite sex. So there's two types of the sexual harassment. There's quid pro quo. It occurs when a supervisor or one in authority of authoritative position requests sex or sexual relationship in exchange for not firing or otherwise punishing the employee, or in exchange for favors such as promotions, raises, anything like that at work. They really affect that person's employment or ability to grow in their employment. There's also the hostile work environment. Sexual harassment that occurs through the presence of demeaning or sexual photographs, jokes, or threats. The inappropriate behavior or conduct must be so pervasive as to, as the name implies, creates an intimidating and offensive work environment. So this is someone, this would be constantly, if you're working in cubicles and somebody's telling a joke to someone 2 cubicles over and saying it loud enough for the whole office to hear, and it just makes the work environment, and they're not appropriate jokes, it must make the work environment very intimidating or even offensive to work. So examples of quid pro quo is threatening to fire or deny promotions to an employee for refusing to cooperate with sexual demands, offering preferential treatment, promotion if subordinate sexually cooperates, basing employee evaluation scores on employees' willingness to cooperate with sexual demands. That's quid pro quo, like this for that. I'll give you this if you do that. So that's what quid pro quo looks like. These are some examples that may contribute to hostile work environment: using indecent gestures, engaging in hostile physical conduct. You know, the big one these days is that Snapchat and social media, posting things on social media about your coworker that may be inappropriate or offensive or just not nice. Emails and texts. We've all accidentally sent an email to someone we shouldn't have, and if it had an inappropriate joke in it or something like that, you know, that can get you in trouble. Jokes, cartoons, and cards. Be very careful printing out jokes or printing out a cartoon and hanging it on your wall. You know, and some Hallmark cards these days can be a little offensive to some. Having sex discussions at the water cooler. Years ago, there was a lawsuit filed under the federal sexual harassment law. They were discussing a specific, it was Jerry Seinfeld. It was an episode of Jerry Seinfeld at the water cooler, and someone found it very offensive, and they were just describing the episode, and a sexual harassment lawsuit was filed, and they won. So just be very careful about that, even when you're talking about certain shows that might be on TV or describing episodes, things like that. Dress discussions. Again, don't walk up to someone and say, "You look hot today." It just is not appropriate for the workplace, and you never know who that will offend, or even stereotypical jokes like the blonde jokes. So be very careful, you know, telling jokes and it's very sad to say, but be very careful about telling certain jokes in the workplace, and they're just not appropriate. So there's myths about sexual harassment, obviously. One of the myths, and the most popular one, is only women can be harassed. And that's not true. Courts have previously ruled that a man can be harassed by a woman. It's slightly more rare, but you know, a woman can harass a man can harass a woman, and it also could be same-sex harassment. So another myth is a woman can't harass another woman and a man can't harass another man. That's untrue. The U.S. Supreme Court recognized that illegal sexual harassment can occur between people of the same sex. Sexual harassment can only occur in the workplace. That is a number one myth that everyone forgets about too. Again, the U.S. Supreme Court ruled that teachers, professors, other individuals with authority in school systems, including universities and colleges, can sexually harass students in violation of the law. So it can be student, teacher, you know, guidance counselor, teacher, things like that. So be very careful there. And only supervisors or those in authoritative positions can be the harasser, and that's not true. It can be a coworker, it could be a third party, such as an agent or a client of the employer. You know, now it's that non-employer. It could be a vendor, a delivery person, a cleaning service. So the key is whether the employer knew or should have known that the harassing behavior was occurring and that they failed to act. So again, it goes right back to that non-employer section of the New York State Sexual Harassment Law now. That is very, very important that you watch for that as well. And if a complaint is made to you by an employee regarding a vendor or delivery person, that you take it seriously, or even a board member. So complaints and investigations. The number one thing here is consistency on how you handle any complaint and investigation. You don't want to handle this investigation one way and that investigation another way because you think maybe one is silly and one is not. Everything is done consistently and impartially. So if someone comes to you, take every complaint seriously. Okay, don't think just because you don't think it's sexual harassment, it doesn't count. take it seriously. If you don't think you can be impartial, have a designee. Investigate thoroughly, ask the questions, talk to the people around everyone, even if it's against a non-employee, talk to them as well and ask same impartial questions that you would ask the victim. Document, and document again. Emails, text, notes, written statements. Make sure it's all written down in a file. But do be careful about documenting findings unless filtered through legal counsel. And it's very, very important here that if you are investigating, you get a complaint and are investigating one, that you run it through legal counsel and have everything marked as attorney-client privilege. Okay? It's really important in these cases. And all employees, regardless of sex, should be treated the same, okay, and with the same amount of respect. Just because if a male comes to you with a sexual harassment complaint, don't laugh it off. It should be handled the exact same as if a woman came to you and complained, and that's sometimes where companies get themselves into trouble. So again, consistency on complaints and investigations is very, very important with this law, and make sure everyone is treated, victims and the accuser are treated with the same amount of respect and the same fairness and the same due process as you go through investigations, okay? So this one was a little quick. Again, do we have any questions on this particular law or the New York State Family Paid Leave Act?
Thank you, Sherry. We do have some questions.
Okay.
Maybe first up, could you reiterate or expound on whether the Board of Trustees of the library needs to receive this training annually?
Yes, they do. Yes.
Okay.
I mean, Board of Trustees, Board of Directors, it's tough because they're employees, but they're not. So they're covered under sort of both employees and non-employees. So yes, because they have the authority over like the director of the library or however your structure is, they are considered part of the library and they should and are required to go through the annual training as well.
What about volunteers who come? We have a lot of volunteers who shelve books or do different tasks at the library. Would you say those folks need to be trained?
Yes, because they have daily, weekly interaction at your libraries, and they act as if someone comes in and asks for their help, they can act as an employee as well. So although they volunteer their time there, they're still seen as a steward of the library, and they should be included in the training.
If somebody received training, somebody at the library, like a board member or a volunteer at their own place of business, does that work, or would they have to be trained at the library also?
Let me think about that. I would still say that they should go through your training as well, because although there is a model of training out there for the New York State has put out there, it's the interactive piece. And how they interact at the library may be different how they interact at their place of business. So I would include them in yours as well in the event that, as they're interacting with patrons and, even the board of directors, their role as a board of director is different than their role at their place of business. And the authority they have may look a little different. So I would also put them through your training as well and your interactive piece, because the harassment could look different. So, and again, because harassment really is sort of like in the eye of the beholder and who is feeling harassed and victimized and offended or feels like it's a hostile work environment. So yes, they should go through yours as well.
Maybe along similar lines, but you said that vendors and contractors, they should be trained, or we should be contracting with people who are trained.
Mm-hmm.
Is there a way to verify that, you think? Should we just ask them, make sure they have this training, or?
So if you have an ongoing contract with a vendor, say FedEx or UPS, probably comes in a lot, or like an office supply store, I would contact their HR just to make sure that they're, in compliance with the law, and make sure, that they're covered, because again, if they're harassing your employee and you fail to act on that, you're still in trouble. And your employee may know the law, and if they're not being trained, that's something that vendor needs to deal with. So you can contact their HR department and make sure that they're complying with that. And if they're not, then I would just be careful. And if someone files a complaint, follow through on your policy, your training, and move forward your way. And then let the, New York State, when it is a vendor, if they haven't complied with the state law, let the state handle that piece. But still investigate and still do follow the policy as you have written in your place.
Okay. Is there an age minimum to be required to receive this training?
No age requirement. So if you have interns, if you're talking about interns or even volunteers that are probably, I would include them. And again, know that they're going to be in the room, and you do have to give examples of sexual harassment, hostile work environment, but the ones I gave are pretty mellow compared to what I have seen in some training. So just when you're doing your training, and again, you can have a couple different ones, right, for younger viewers versus older viewers. So if you have some teenagers in the room, you can give examples, but you can keep them pretty low key. So just be aware of that.
Okay. What would the library or a business's responsibility be for, like, we call them library patrons, but like, what would a business's responsibility be for a customer who comes in who might be sexually harassing library staff or volunteers or trustees?
So again, they're a non-employee, so they would be considered as such. You're in a service industry, right? So even in a restaurant with a waiter, waitress, and it's a customer that comes in, you have the same responsibility to your employee to treat that patron, if they're sexually harassing one of your employees, the same as a non-employee, and the complaint can still be filed. And then in the policy for how you write the sexual harassment policy, you would have to include maybe steps if it's a patron, right? And it may be the same as a non-employee, a vendor, same steps, or employee to employee, maybe you would take the same steps, but you would have to make sure that patrons, they're included as a non-employee. So, you could even write an extra step in your policy on how you would deal with that. Would you ask the patron not to return? Things like that.
Okay. If anybody has any questions, feel free to type them into the chat box about either the paid family leave or the sexual harassment prevention. I have another question. Is the library director, if they were the ones to handle a complaint about sexual harassment, would they be required to report those things to the Board of Trustees?
Yes. I would say that any complaint investigation, make sure your legal department, or legal counsel is involved, whether you have internal or external for the library system. And I would keep your board of directors or trustees. I don't think they need all the details, but I would keep them informed that we have this complaint, we're following our policy, and this is how we're handling the investigation, and this is the outcome of that investigation, and then here's the recommendations for resolution. So the board and trustees should be kept apprised at that level. But You don't have, I don't believe, and nothing in the law says that you have to let your board of directors or trustees know everything, like details, you know what I mean, like who, what, when, where. You just keep them apprised that we've received this complaint. This is the steps we're taking following our policy for investigations. And here's our discovery, and here's our resolution. And most of the time with these complaints, you will probably, again, you will be in contact with your legal counsel, and they will walk you through it, because a board of directors, trustees is typically covered under attorney-client privilege.
Okay. If somebody leads some of the training using the resources that are available from New York State, are they considered trained?
I mean, yes, because they're doing the training. They are involved in the interactive piece. I mean, you could have them sit through, if you have a couple people doing the training, you can have them sit through the other person's training as well. But yeah, I believe they would be covered. If they're doing the training, they've helped develop it, they're involved in the interactive piece, and they're present, and they're listening, you know, and taking the questions, and they're listening. And yeah, I would say that that's part of the, they would be covered under the training.
Okay. We had a question, again, any questions from everybody about the PFL or FMLA or sexual harassment prevention, please put them in the chat box. We have a question about the PFL. School district libraries are not required to opt into the PFL, but are required to comply with FMLA. Is that true?
Yes. The Family Medical Leave Act does not exempt, as far as I know, and I don't believe does not exempt public municipalities and institutions. FMLA, it's broad in its coverage. They are covered under FMLA, and part of that is because honestly, there's no cost to the employer other than requiring people to take their PTO. So PFL is the only one, and the FLSA allows public municipalities and things like that to, they can't opt out of the Fair Labor Standards Act, but they can allow comp time, versus private employers cannot allow comp time. So yeah, they're still covered by the FMLA. They cannot opt out of that.
Okay. Okay, maybe we'll give it another minute. If anybody has any other questions, please type them in the chat box. Sherry, thank you very much for the presentation today. We appreciate it. And of course, we have another one coming up, right?
Yes, in March, correct?
Yes, on March 26th on Tuesday at 2 p.m. We'll be going over key employment legislation and compensation issues. So everybody, please sign up for that at midhudson.org if you'd like to join us. And I don't know if we're going to get any more questions, but if you do have questions later today, later tonight, next week, if you wake up and you think of a question about this, please shoot me an email and we'll get in touch with Sherry and we'll get an answer.
Yep.
All right. Thank you, everybody, for coming. Thank you, Sherry, again. I appreciate your time.
No problem. Thank you.
All right.